You may be seated, Mr. Njepe.
Mr. Njepe, will you just push the button on your microphone, please?
Mr. Kennedy, did I say we'll stop at 2:45 without saying 2:45 what, or did I say?
You said 5:45, if I heard correctly.
Oh, okay, all right. No, then it's, I thought I just said 2:45 without saying when, because I was under the impression that we are after 5. It was after 5, but it's not after 5 yet.
No.
Yeah.
It may feel like a very long day, but it's not.
So maybe we'll stop at about 22:06 or thereabout.
20 to 6,
So
thank you. We'll try to finish.
Yeah.
I'm hopeful we will.
And then if we haven't finished, we can start early tomorrow, as we previously discussed. And then once we are done with him, then tomorrow's witness can follow.
Thank you, Chair. May I ask if there's still a problem in the afternoon when Mr. Seleka, my learned friend, indicated may be heard tomorrow, but...
Well, as things stand, the plan is that he will still lead that witness, but from what he has said and from what he has told me, he might take between 30 minutes and an hour. There is room for us to continue subject to that hour. So as I see it, we certainly could still go up to 5.
Thank you, Chair.
With Denel.
Yes, thank you.
And then his witness could come after that.
Thank you, Chair.
Yeah, would that be okay with you in terms
yes,
of
I hope that we should be able
of time?
Yes, I hope that we'll be able to finish.
Okay, all
Thank
right.
you. Chair, may I just deal with a few aspects still to be dealt with in relation to Denel Asia. The product that you were intending to get VR Laser to produce for sale into the Asian and especially the Indian market, was that the armored vehicle similar to the one that VR Laser was awarded the contract to do for Denel for the South African market?
In my understanding, correct.
Yes. Yeah. But the Chair has already heard evidence in relation to the procurement or the award of that contract to VR Laser. And some witnesses have contended that VR Laser was not the only one that could do such a product. In fact, LMT in that tender had not only tendered to produce those items, it had been producing similar items previously and was able to do so much cheaper than VR Laser. Now, I'm not going to go into the detail of that award at the moment because we're focusing on Denel Asia. But my question is, why would you be giving the business to VR Laser to do this without following any sort of tender process for the market aimed in Asia, when in fact there were others, such as your own in-house company LMT, able to do that production?
Chair, there were 2 reasons. One, we did not have 100 million rands to start the marketing campaign in India. Before our banning in India, we spent over 300 million just in the marketing campaign, Denel, and we never ended up getting a contract. So the risks of spending a lot of money in India, because in India they evaluate at your own risk. In other words, you can spend R1 billion in getting your system to be what they need. They can still say no, and they are not obliged to pay you any money back. Firstly, so there was no other company that was prepared to have 100 million. Denel did not have 100 million to go back to India at that point in time to go and start marketing after being away from the market for more than 10 years. That's number one. Number two, the vehicle which Denel was going to vie for in India It's similar, but not exactly like the one in South Africa, number one. We were also going to, not only via laser or Denel Asia alone in India, we were going to have to get an Indian company in India to be able to be our partner, and that needed to make sure that also that company will have to contribute to the operations of the organization. And because buy and make India means that some technology will remain in India, and therefore the Indians will want to make that product themselves in the end, like we are making the whole fixture ourselves, because we got the IP from Patria, licensed IP. So it is two reasons. One, the marketing costs were very high, and LMT did not have the money to do that, and nor did Denel. And secondly, was that you also needed to get an Indian company to be involved in India to be able to do that.
Well, let's talk about the first reason. Why is the position not this? That if you think VR laser is going to assist Denel by injecting 100 million rand into the project, what's wrong with you still putting this out to tender? Because when they tender, they will include that benefit, and if there is no other bidder who is able to do that, you'd still then go with them, but you will then have complied with the requirements of procurement.
I could be wrong, Chair, but my understanding, when you want a partner to do business, especially in the corporate world, because Denel, though it was a state-owned company, had to operate within the Corporate Act, the Companies Act. And therefore, you do not go out on a tender. Like, for instance, when we got the Rheinmetall, Denel, it did not go out on a tender. It was Denel and Rheinmetall that came into an agreement that this is what we are going to do. It's not only Rheinmetall, there's also Zeiss, Carl Zeiss, which was the same thing. So I did not see an anomaly in the sense when VR Laser was going to be our partner, because the issue is competitive advantage. We believed that if we have VR Laser, and number one, competitive advantage in terms of cash. We did not have any cash. And number two is that the links within India themselves. Although we were there 10 years ago, we were not there anymore. So, and the companies that we knew were already partnered with.
Yeah, as you see, I'm putting to you this question because when your answer to Mr. Kennedy's question, which was, why did you not go follow procurement procedures? You said the first reason why you didn't do that was because VR Laser was going to inject 100 million rand, but from what you say now, I think what you are giving might be a different reason, but whether it's valid or not, that can be looked at. But you are now saying, well, your understanding was that when Denel got into a partnership with another company, then procurement procedures would not apply. That's what you're saying.
Which is the experience I have.
Yes. Sure. Mr. Kennedy?
Thank you, Chair. What was the 100 million rand intended for? Marketing costs?
Yes, initially that was the concept that we will spend 20 million rand per year for 5 years.
And did VR Laser actually put up the 100 million rand? Was it spent?
No, not at all. There was no cent spent.
Is that because the project collapsed?
In my understanding, yes.
Right. Now, you said earlier that Denel couldn't come up with the money, 100 million rand, and only VR Laser could come up with that sort of money. Did you actually make inquiries through a public participation process to find out? Did you, for example, advertise your intention to enter into a joint venture with a suitable partner to market products in the Asian market and say to the marketplace, all potential competitors, if you're interested in tendering, we will give you an opportunity, but please note that you will have to put up 100 million rand for marketing costs. Did you undertake such a process?
No, we did not take it.
But why not? You said that VR Laser is the only one with that with that money. But how do you know unless you go out on a public tender or similar process? How do you know whether there might be anybody else out there interested and able to do it?
As I've indicated, we have done this before. And we have done it with Rheinmetall, and then we have done it with Carl Zeiss.
You've done what before?
Joint ventures.
Joint ventures, yes.
Yes, and there never was a public tender.
Yes,
Yes, you see, that's a different reason. You see, you said you didn't go out to open tender because VR Laser was going to inject 100 million rand. So Mr. Kennedy says, but how did you know that there was not going to be another entity that could do the same? Then your answer now is, we had never done that before whenever we do a joint venture, you see, so that's a different reason. But of course, if that's what you intend doing, to say, okay, you understand Mr. Kennedy's argument, but here is another reason that influenced you, that's fine. Is that what you are saying?
Chair, if maybe I can repeat, we did not go out on a tender to do that, in short. And why not?
Yes, but he was asking the reason why.
Why not?
Yeah, and you had initially
Yes.
said it was because of the 100 million rand.
Yes.
And then Mr. Kennedy said, but if you didn't check other companies,
Yes.
how could you know that there was no other company which could do the same?
Yes, we did not
And
do
then
that.
you said, well, whenever in the past you had done joint ventures, you had never gone out on open tender.
No, we have never.
Okay, Mr. Kennedy?
Thank you. So the next question must be, Mr. Nsepe, the fact that you had never done it before, does that mean that you didn't have to do it this time? If you'd always followed a practice where you didn't comply with any tender requirements, that is no reason why you shouldn't comply with it if the law requires it.
Correct.
So,
But
was it in fact not expected and required of you, leaving aside what your practice may have been, whether that complied with the law or not previously? Wasn't there a requirement, at least for this procurement, where you would be procuring large-scale supply of very expensive vehicles for you to sell in the Asian market? The mere fact that you'd never complied with the tender process surely wasn't an excuse not to comply with it again.
correct. But what needs to be noted is this. The defense market operates slightly differently from the other industries. The tendency is that when you form a joint venture or a partnership, you already have to identify the partner, who the partner is. And this is what has happened before. But it is true that if in terms of the law or in terms of what is required in South Africa, I think that's where one of the things that needs to be clarified with the defense industry. How do you go out and form, especially if you are a state-owned company, how do you form a joint venture? If you follow the normal processes, not necessarily are you going to be successful in doing that, because it might not necessarily be the partner, because the point is, might not necessarily be the partner that will help you to win, because the issue is to win the contract. It might not necessarily, I'm not saying it's not, Chair. So in terms of that, this has been the norm in the defense industry. It might be wrong, I concede, but this has been the norm, and this is what has been happening for a very very long time in the defense industry.
You see, isn't the position that supply chain management policies, Section 217 of the Constitution, which ought to be known by CEOs and high-ranking officials of any state-owned entity, says whenever you are going to procure goods or services, you must do so in a manner that's fair, that's cost-effective, blah, 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 blah. Therefore, shouldn't you simply be saying, am I procuring goods or services? If I am, then I know what the law is that applies and the procedures that I must follow.
Correct, Chair.
And if you are not going to be procuring goods or services, that might be different.
Correct, Chair. But you are forming a company. Yes, a different company from the existing company. Mm-hmm. And therefore, the operations and the manner in which, and the philosophy behind the formation of that company is not necessarily in line with the 217 Procurement Act, especially in defense companies. This is what I'm saying.
But of course, in a case such as this, the idea was to procure particular vehicles or whatever, or products, isn't it?
No, it was not to procure any vehicles made by via laser in South Africa or whatever. The design will come from Denel. The steel we believe will come, because usually almost all steel in South Africa is sold by via laser, and then the welding will be done by via laser, and that also depends if you win the contract, and you can only win the contract if you are joint. We have already formed the joint venture at that point in time. But if it was just a pure straight procurement, I can understand what you're saying. Actually.
Mr. Kennedy.
Thank you, Chair. If I may just complete with one or two questions.
Yes.
But VR Laser would not have gone into the joint venture if it wasn't going to derive a lot of financial benefit. Not so.
Correct.
And especially in the defense market, if this project had taken off,
correct,
it would have been very lucrative, not so for VR Laser.
Correct.
And hopefully for Denel as well.
If it's lucrative for the VR Laser, it must be lucrative for Denel.
Yes. Now, VR Laser, in fact, was taking not just the lion's share, it was taking the entire 100 million rand up front for marketing costs to get the project off the ground, not so.
Correct.
It would never have done that if it wasn't going to get a lucrative benefit at the end. So you were marketing, you were intending to market the joint venture in order to obtain contracts from the Asian market, correct, which would then be would be for goods that would then be manufactured by VR Laser.
No, what the goods would have been manufactured, because largely the design engineers come from Denel. The goods.
Sorry, I was talking about manufacture, not design.
Yeah.
Who would do the manufacture?
The manufacturing largely would have been Denel, because they can't make a gun via laser.
VR Laser, but they would have been manufacturing components, not so.
Yeah, certain components.
Including the hulls, not so.
If we got the contract, yes. Not necessarily all the hulls, but yes. I think they will be measuring. I mean, that would be reasonable to think like that.
But if in fact, sorry, may I just stop for a moment? The Constitution that the learned chairperson has referred you to says in Section 217, as the chair put to you, when an entity such as Denel, we're not talking about a private company here, we're talking about a state entity such as Denel, is procuring goods and services, it must follow, as the chair said, a process that is fair, competitive, etc. It doesn't say except where it's Denel, and it doesn't say except where it is dealing with the defence industry, and it doesn't say except where it does so by way of a joint venture. The Constitution, of course, is our supreme law.
Correct.
So if one accepts that Section 217 of the Constitution requires Denel, whenever it is going to get into a relationship with a provider, in this case, a provider in a joint venture, and I understand the vehicle would be a joint venture, but at the end of the day, VR Laser would be benefiting largely through the production of the relevant items that would go into the finished product. So was it not appropriate for you, if you didn't know this already because you've been following the practice, was it not appropriate for you to at least take advice and find out, is this permissible under law? Can we do this without going out on a tender or similar process?
What informed me to continue with this was the precedents that I've seen before in the company. The precedents, and I'm just quoting a few joint ventures that we have done. We have done joint ventures in the Middle East, and there was no tender.
Mr. Nsepa, I have no difficulty with your point. I don't know those facts.
Yes.
But let's assume that you're correct, and I'm not suggesting anything to the contrary. Let's assume that there were 10 different joint ventures before this one. It was at number 11.
Yes.
Was it not necessary for you, particularly once you were at the head of business development and then as acting group chief executive, to make sure, to be questioning in your mind, I know that the law has developed over the years. Not only was the Constitution adopted in 1996, but the PFMA was adopted in 1999, and then Treasury regulations keep coming out. So what we may have done in the past, are we up to date with the legal requirements? You seem to be saying to the chair, if I understand you, and if I'm being unfair or incorrect in my understanding, please tell us. But you seem to be saying, because we've done it this way 10 times over, that means we don't have to do it.
Two things I'm saying to the chair. One is that is the past. Now, in the present going forward, we did not do that. We were still adopting the processes of the past. That is what I'm saying.
You must just tell me if I misunderstand you. I understand you not to be contesting necessarily the proposition that procurement laws and supply chain management policies were applicable and should have been followed. I understand you to be saying, I don't know, but there was a practice that had happened before, and because of that practice, I acted in accordance with the practice.
Correct.
If you tell me that Section 217 of the Constitution was applicable, if you tell me that procurement laws were applicable, I don't know, I'm not contesting that, I don't know, but there is this practice that had happened and I followed it. All I can say is based on that practice, I thought if I acted in accordance with that practice, that was in order. But if you tell me that it was actually wrong because procurement procedures should have been followed, I accept that.
I accept it. Chair.
Okay. Mr. Kennedy.
Thank you, Chair. If I may just take you back to page 499, paragraph 1.5.
Of course, I'm sorry, Mr. Kennedy. You may or may not take this further at some stage. Of course, there would still be the question of whether somebody at the level of group CEO of a state-owned entity such as Denel, whether or not they would not be expected to know that procurement procedures or laws are applicable.
Yeah.
Of course, when one looks at that question, one won't forget the practice that he's talking about. But it doesn't close or the inquiry. So, but you'll decide whether you take it further or not.
Thank you, Chair. If I can just pick up this question and then
Yes.
return to the point that you have raised, Chair, with the
Okay.
witness. On page 499, you say in paragraph 1.5, according to the opinion which was sought from senior counsel, the board resolved to explore a suitable equity partner for the Asia-Pacific region. Now, you haven't provided a copy of that opinion. We're not sure who the senior counsel is or what he or she may have been asked to advise on, or what the advice was. Can you enlighten the Chair?
The issue was when we were not, Chair, when we were not getting any reply from Treasury. So we wanted to know, the board wanted to know have we followed the processes correctly. So we went to senior counsel, and I mentioned last time when I was consulting that it was Mr. Bana, senior counsel Bana, and this is the chronology of events in support of because I think we went to court, yeah, and so this is public knowledge. It should be in the public papers.
So that was after you had not got a reply from Treasury, you then went to senior counsel?
Yes.
Isn't there a difficulty in what you just said? Because your chronology indicates in 1.5 that you received an opinion from senior counsel, and according to that, presumably because you were given advice in that opinion and on that basis, then the board resolved to explore a suitable equity partner. And what then followed is the chronology in 151, etc. 28th October 2015, 29 October, and so forth. Treasury was not involved until much later. In fact, if we get to your own chronology, you first mention Treasury at the top of page 502, which is para 1515, which deals with something that occurred long after the board meeting. And that was on the 5th of February 2016. A letter came from the National Treasury's Chief Director for Supply Chain Management Governance, Monitoring and Compliance to Denel, requesting information to determine whether government prescripts were followed in the formation of Denel Asia. So isn't your chronology back to front? Your chronology seems to be this, according to your affidavit. You go to senior counsel to ask for advice. You don't indicate what that advice is. And then you say, on the basis of that advice, the board resolved to explore a partnership for the Asia-Pacific region. And that is then followed by a whole lot of steps, which include the formation of the company, etc. And only thereafter, at the end of 2015, beginning of 2016, you've now got the 30-day period expiring where the Minister of Finance and Minister of Public Enterprises don't get back to you. And only thereafter does Treasury first get involved. I'm suggesting to you that your evidence can't be right, that the Council's opinion came after Treasury was approached.
Yes, correct. It might be then the way we've put the 1.5. There's no way that we could have asked senior counsel to form a joint venture.
I'm sorry, just repeat that last sentence.
There is no way that we could have asked senior counsel, an independent senior counsel, if we can form a joint venture or not.
Oh, that you well, would have been your own
that
decision.
had been already been done.
Yes, okay.
It was a response to now to saying that Treasury is not responding to whether are they saying yes or no.
On Section 54 application.
Yes.
Okay.
Yeah.
Now, you haven't provided a copy of that senior counsel's opinion. Did that senior counsel, in fact, give you advice to do with procurement processes, or did it deal with other issues?
It actually dealt with the issue of I think it dealt with other issues, in particular the issue of
Section 54.
yes, which we went to. I think we went to court to try and see if we can get an answer from Treasury.
So it didn't deal with whether or not you had to comply with procurement processes?
No, to get an answer, because we already had submitted the application to.
I'm asking simply, did senior counsel give you advice dealing with whether or not you had to comply with procurement processes?
No, we did not give us advice on that.
Right. Now, if I can take you back to this paragraph, I drew your attention to top of page 502, a letter from National Treasury's Chief Director, Supply Chain Management, Governance, Monitoring and Compliance. Now, this is almost, as it were, the watchdog for government in its various entities and departments, not so? Correct?
Correct.
So watchdog to ensure that government departments and entities such as Denel are complying with procurement processes. And so that letter is then sent
Yes.
and asks, has it been complied with? And then you refer to, in 1516, to the chairperson of the board, that's Mr. Mansa, correct?
Yeah.
He addressed correspondence to Minister Brown, providing detail regarding the formation of the joint venture in Denel, Asia.
Correct.
But then, so that's not dealing with the National Treasury query, not so? Dealing with other issues. It's dealing with the formation of the joint venture in Denel, Asia.
Yes.
And it's a reply to, it's a correspondence with Minister Brown. She's not part of Treasury, not so?
Yes. Correct.
Right. And then you deal in 1517. You say the chairperson addressed a letter to National Treasury indicating that the response to National Treasury's 5 February 2016 letter would be forthcoming once sign-off from the board has been obtained.
Correct.
Now, can you explain, obviously you weren't the chairperson, and you've said he addressed a letter to National Treasury, but did you not give input to the chairperson as you were acting GCEO on that letter?
We had various meetings with the Chief Director at National Treasury in trying to resolve this issue. I think we had 4 or 5 meetings before this letter was written. And we would report back to say that this is where we are and this is how far we have gone in terms of discussions. But we were not moving on that. And actually, we still owed them a letter in response to that question at 1.5.15. So, in terms of the input to the letter, we gave input to, because the chair is not operational in the company.
Exactly.
Yes, we gave input to the chair, and the chair was able to write the letter to National Treasury.
But this paragraph indicates that the chair, presumably based on your input, said that his response about the procurement query would only be given once you got sign-off from the board. Is that correct?
This is part of the response.
Yes. And unless I've missed it, you've not dealt elsewhere in the affidavit with any later response that may have been sent to Treasury. Was in fact there any response sent to Treasury to deal with?
There were many correspondence between Denel and National Treasury during that time. We would go and see the DG, Mr. Ondo, if I'm not mistaken, and then his team. So there were many interactions. So I would not necessarily know exactly in the meetings, which meetings did we address these issues exactly, in terms of responding to these letters and in terms of being able to find an answer into our problem of saying that, are we going ahead or not?
Now, may I take you to page 507? You refer to the trip in around February 2015 this is what you've clarified in your supplementary affidavit, that in fact there were 2 trips, and you refer to here that the trip in February 2015 to try and find partners before the key ones were already taken. For example, Barry Forge had partnered with the Israelis, others had already partnered with the French, South Koreans, etc. No stakeholder was misled. Now, is this what you're referring to here? Is this the first meeting that you went on without VR laser?
Yes,
Right.
in 2015.
Yes. And then you say, in fact, one of the companies realized that Mr. Kamal Singhalla was related to the Guptas. He immediately agreed to explore a partnership. I therefore cannot, well, that's in response to the investigator's question. Who is the company that you refer to, realizing that Mr. Singhalla was related to the Guptas, which meant that, which led that company to say, well, in fact, now we're keen to explore a partnership with you? Who was that company?
The company was Reliance
Reliance. And is that an Indian-based
company. Yes.
company?
Yes.
Right. Now, yes. Now, what I don't understand is this. If this discussion took place in the first meeting, early in 2015, around February 2015, where you weren't accompanied... Sorry? February?
2015 was to explore the possibilities of forming joint ventures or partnering with Indian companies in India.
Yeah.
And then in 2016, that is the discussion that took place.
The discussion
With Reliance.
with Reliance.
Yes.
So are you saying that, in fact, this discussion where Reliance was saying, oh, this is exciting, we've got a Gupta company with Mr. Singhalla as one of the Gupta family, that means that we're keen to explore a partnership. Was that what happened in March 2016?
Correct.
Okay. Would you agree, Mr. Nsepe? I'm afraid this paragraph has led to huge confusion.
That's correct. That's why I apologized and said it was a mistake.
But it's confusion in a particular context which makes it a bit disturbing. And that is that where this commission is looking into allegations of state capture, some of which involved the Guptas themselves, it's important for the commission to understand all the facts. And the way one reads this paragraph of your first affidavit that, of course, you swore an oath to when you deposed to this affidavit, the way this reads, before you corrected it later, in fact suggests that as early as February 2015, not in March 2016, but as early as February 2015, you were already going to the Indian market and saying, we're going to be in a joint venture with some of the Guptas. You see the difficulty?
I beg to differ, Honorable SC, because I did correct the mistake.
Yes. Now, if I can ask you just for a moment, may I have a moment, Chair?
Okay.
Thank you. Now, if I can take you for a moment to page 529. Paragraph 18. This is in the supplementary affidavit. You said the trip we undertook in February 2015 did not include anybody from VR Laser. It is only around March 2016 we went to an exhibition with VR Laser in Goa. It is in 2016 that Denel officials used the VR Laser aircraft, not in February 2015.
Correct.
So, how did you go to India in February 2015?
We use a commercial aircraft. We use a commercial airline.
Normal flight as a normal passenger on a commercial airline?
Yes.
But in March 2016, you went to the exhibition in Goa on VR Laser's transport, is that right?
Correct.
Right, that then takes us back to page 507. There you refer to the purpose of the trip, but here, of course, you seem to be referring, although paragraph 1.11 said the trip was in February 2015, you've corrected that in a later affidavit, that the trip that you're referring to in 1.12 is not the one in February 2015, but the one in March 2016. Correct?
Yes, in Goa.
Yes. And then in the third line, VR Laser offered to travel with Denel at no cost to Denel. Since Denel had always been in financial distress, we saw nothing wrong with the use of their aircraft at no cost to Denel. Further, if VR Laser was going to be our partner, why would we be unwilling to travel with him?
Correct.
Now, yes, and Mr. Singala was on that trip, is that correct?
To Goa, yes.
Yes.
Correct.
Who is Mr. Singala? Kamal Singala?
Initially, I did not know who Mr. Singala, but I knew that he was, can I say, related to the Guptas? And it always puzzled me, why is he using a different surname than the Gupta surname?
Yeah.
But then I realized that no, Mr. Kamal Singala is a relative, or is related to the Guptas.
Is that what you were told, or it was just your suspicion?
Well, you know, as you interact with someone and you realize, you pick up some things that, you know, and also saying that he was staying in the Gupta house.
That he was staying at the Gupta house?
Yeah, in Section
Yes. Of course, he could be a friend as opposed to being related. That's what I'm trying to, why you would say he was related.
Well,
because if he was one of their friends, he could stay with them.
for a long time, Chair, I doubt, because he seemed to be very involved as a family in the Gupta family. And
But is your answer to my question that nobody told you that he was related to the Guptas?
No.
It was your
just my
own,
deduction.
your
Yes.
own thinking.
Yeah, my deduction.
Okay.
Yeah.
One of the other witnesses has indicated that to his understanding, Mr. Singala is in fact a son of one of the Gupta brothers.
Yes, I read that.
You read that?
Yes.
And do you know if that's true or don't you know?
I think it could be true. I cannot
Okay, thank you.
emphatically say it's true or not, but I think it could be true.
Right, thank you. Can I ask you to turn to page 508? You say in paragraph 1.15, I do not have any relationship with Mr. Salim Issa. Were you aware that he was connected to the Gupta family?
I only realized after some time, after I've had some interactions with him, that he has a Gupta relationship.
Then you say, I was introduced to Mr. Salim Issa by Rio Saluji around 2012-13 at a cafe in Oaklands. Mr. Saluji instructed me in Mr. Issa's presence that I would work closely with Mr. Issa, but because he is trying to enter the defense market.
Correct.
That, of course, was some years before you were going in the VR laser jet.
Correct.
To India. Yes. So was Mr. Saluji saying he instructed you in Mr. Issa's presence that you must be working closely with Mr. Issa because he's trying to enter the defense market?
Correct.
Not simply the defense market that may exist overseas in
No,
Asia.
it was very clear that is
Generally.
saying the defense market, and in my understanding is that Denel should help Mr. Essa to be established in the, because I was a Denel representative. When he says that he was putting me in between, that's why I get upset, because I don't understand why would he use me.
Now, let me understand why you've used the word instructed. Instructed you that you would work closely with Mr. Essa. Did you understand that this was an instruction to favor Mr. Essa or VR Laser?
It was my understanding that it was an instruction to say, because
Instruction to?
An instruction to say that because Mr. Essa has now bought VR Laser and is a black-owned business, we should be able to help them to gain a foot into the defense market.
Did that mean that you should actually give favorable treatment to them? If not, what was being said?
I had no power to give anybody any favorable treatment because I was not in any line of business, part whereby I would say, you do this for, I mean, when I was group business development, because my business was to combine businesses to work together.
Yeah.
But I would not be able, and if some failed and some succeeded.
Yeah.
So that is the instruction the way I understood it. But not necessarily to do a particular favor, but to make sure that I grow the relationship that this company that has been bought by Mr. Essa, who is classified in the BEE, should also be involved in the defense market.
Now, you've mentioned the black ownership issue, and there has been other evidence, and Mr. Saluji will also give evidence, we understand, dealing with the importance of transforming the defense industry,
yes,
particularly in relation to Denel, which was traditionally basically white-owned and dominated. So I can understand that would have been an important objective.
Correct.
But are you saying that Mr. Essa, so I beg your pardon, Mr. Saluji, was saying to you that you should encourage VR Laser, or are you saying that he was expecting you and instructing you to cut corners, to break the law or to violate procurement processes or anything of that nature?
My understanding was, using your words, as Honorable SC, was to encourage, because they had no clue about the defense business.
Right. They had no clue about South African defense. Is that what you said?
The defense business,
Yes.
at that point in time.
They had no clue about it.
Yes.
They had no knowledge about it.
Yes.
And they had no previous experience in what?
In the defense business.
In the defense business.
Yes.
But of course,
But they were buying into a company that had or Mr. Essa was buying into a company that had a long history.
yes, exactly.
Yes.
So it was now that VR Laser, that had a long history in the defense business,
Yes.
that while they as owners new owners might not have experience and knowledge of the defense industry, they were buying a company that did.
Yes.
Yes. If he had in fact been suggesting to you that there should be a violation of the law, and especially to do with the PFMA and procurement, what would your attitude have been?
I would have told him that it's not possible because you are putting me in a quandrum, because in the end I'll be the one who is responsible for it. And you can always deny it and say you never gave me that instruction. So I would have a problem with it.
Right. At page 509, paragraph 1.18, you say that the Gupta family was involved in the preparation of the Section 54 application is not true. Application was prepared by my team, comprising of Ms. Govender, Ms. Lechwabe, Mr. Biela, and Mr. Mshluwana, to mention just a few.
Correct.
You confirm that. Right. May I just have a moment to confer with my team? Thank you, Chair. With your leave, may we then move away from this topic of Denel Asia
Yeah.
and move on to page 510 of Mr. Ntsepe's affidavit, and that deals with the VR laser contract that was awarded by DLS for the hull platforms. Correct, Mr. Ntsepe?
Correct.
Now, there were initially to be 217 hull platforms. Later, it was reduced to 183. I don't believe anything turns on that, though. And you, there in 2.1, you say the instruction was to support VR laser services and not to favor it. Now, that appears to come from a question that you were asked to reply to. In fact, as I understand it, your paragraph numbers in your affidavit respond exactly to the paragraph numbers of the questions. Is that right?
Correct.
So if we can page back for a moment to page 491. 2.1, during the interview you attended with the investigators of the Commission, you stated that you were given instructions to support or favour VR laser services. Please respond to the following questions. Who gave these instructions to you, using what kind of communication? And the various other questions are put. So if I take you back to page 510, is this a direct answer to the question that you were asked to provide?
Yes.
Right. So you say the instruction was to support VR laser services and not to favour it. Favouring it was out of the questions as I'm not involved in initial engagement of the entity. I've stated when and how I got involved, and that does not merit any further mentioning again. The instruction was given by Mr. Ria Saluji through verbal communication. Now, so the instruction that you say you received from Mr. Saluji, that was to support VR laser services, but not in a sense of favouring it.
Yes.
In other words, not in the sense of giving it some advantage which it wouldn't have legally been entitled to.
Correct.
Right. And when was that instruction given to you? Was that the instruction given to you at the restaurant in Oaklands in 2012 or 2013?
Well, in the instruction was to work with in Oaklands 2013. But because I was reporting to him every week of the progress of how things are going, I would not remember exactly the day and the date.
Yes.
Yeah.
You say at the top of page 511, paragraph Roman 3, presumably in answer to the specific question as to when that instruction was given, you say, Hoof has to start in 2007. I think the instructions were given in 2013. So that would seem to correlate with your earlier evidence about the lunch at the restaurant in Oaklands.
Yes, it wasn't lunch. It was just a cup of coffee.
It was a cup of coffee, I beg your pardon. Right. And then in paragraph Roman 4, it says, since we've been doing business with VR Laser for a long time, and now that it's been acquired by a black person, we need to support the growth of black business in the market. Again, while transformation is a healthy objective, and of course there's legislation as well as government policy that promotes it, and in procurement, provision is made for scoring in relation to the triple BEE component. This didn't mean that you were simply going to give a contract to VR Laser
No,
if it didn't satisfy tender requirements. Is that right?
No, it did not mean that.
Yes. And in fact, we've seen through the evidence of other witnesses the documents relating to this procurement process, where in fact triple BEE constituted a major scoring percentage. In fact, quite a bit more than price, not so.
Yes.
Yes. Now,
can I just go back a little bit?
yes.
You have made it clear that the instruction from Mr. Saluji was not that you should give VR Laser any advantage.
Correct.
But it was to give it support. In practical terms, what did you understand this support that you were supposed to give to them to entail?
Like, for instance, what is involved in the defense industry, locally and globally. Like, for instance, what is involved when you although they could, I mean, I was talking to Mr. Essa, not to the company. What is involved when you have to get a permit to export products outside of this country? You cannot just export. You have to have a permit. Like, for instance, the exhibitions that we have internationally. For them to understand what is involved in that, and further to understand that in those exhibitions, really, initially it's the manufacturers, the OEMs, for the first few days, and then thereafter is for the public. Why they do it like that is because they want to give the OEMs an opportunity to be able to see what other companies are manufacturing. And maybe there might be joint ventures, maybe there might be relationships, things like that.
So basically, as you understood the instruction to give support to VR Laser, to Mr. Salim Essa, your understanding was that it was to share with him information about the industry, the defense industry,
Yes.
And to assist him to understand how it works.
Largely that, but there are also other activities, like, for instance, if we have to, maybe there was a show, if I still remember,
Main events in
Yeah.
the industry.
Yes, and also introduce them to the association,
Yeah.
of him in particular.
Okay, all right. Mr. Kennedy.
Thank you, Chair. Now, you then deal on page 512 with LMT, and you say in Roman 1, I was not involved in the identification of LMT, so would not know who identified them. LMT had experience but limited by capacity. And in paragraph Roman 4, I do not know who took the decision to invite other suppliers to bid against LMT for the manufacture of the hulls, and when that decision was taken. I assume it was the division mainly involved in the use of the hulls, that is DLS.
Correct.
Now, in fact, your assumption is correct, it seems, in the light of evidence that has been given by various DLS witnesses, that in fact it was decided to invite bids, and they invited 3 entities, the one being VR Laser, the second being LMT, and the third being another entity that was also involved in the market. Now, then you say, in paragraph Roman 4, the process, if I remember, was done at divisional level. I'm not in a position to say whether or not PFMA dictates were not followed. So you aren't able to say whether the procurement requirements under the PFMA and presumably the Treasury regulations and the supply chain management policy were complied with or not.
On the house?
On the hulls,
Yes, no, I'm not in a position to do.
Yes, we're going to deal at a later stage in your evidence with the contract that was awarded for the single source supply of various steel and other components, which you in fact authorized. We'll deal with that in due course. Right. Now then you at page 514, return to the issue of procurement, because you say in 2.5, it should be clear that at the time Mr. Mlambo rejected to approve the submission to appoint VR Laser Services, the MOA, as the Memorandum of Agreement, had already been signed, and there were certain obligations which Denel had to meet in terms of the MOA, and any failure to comply with such obligations would have opened up Denel to litigation. VR Laser Services would have been within its rights to sue Denel and claim damages, as there was a binding contract already. It would have been foolish for anyone to renege from such agreement and expose Denel to litigation and payment of large sums of money in damages at a time when Denel was going through financial difficulties. mine, presumably my role, was to look what was best for Denel at the time to avoid plunging the entity into further abyss. I must point out further that the program was about 3 years late, and obviously Denel was incurring penalties for the late delivery. So there was pressure of finishing the baseline demonstrations for the Hoefeester, which was about 3 years late already. This would show that the cost of not going ahead with the appointment based on what Mr. Mlambo stated the reasons to be for his rejection far outweighs all reasons for the rejection of such appointment. In my view, his decision was not based on fact, but on emotion, and Denel could not afford to delay further.
Correct.
Now you reflect on this, on what you've said in this affidavit. Can I just check with you? Are you not here confusing Mr. Mlambo's rejection of approval after the contract was already signed? Are you not confusing this, which deals with the Hulls contract, with a further contract, the single source, single supplier contract? Because there we have heard evidence, the Commissioner's heard evidence, and we will take you through the evidence, the relevant documents and so forth. We know that in relation to the single supplier, Mr. Mlambo was asked for approval after the event. And you at that stage were acting GCE. And you said, well, we have to go ahead because it's too late, we've already signed the memorandum of agreement. That appears to relate to the single source, single supplier contract with steel items, not to the Hull contract that you're dealing with here in this paragraph.
Here I'm dealing with the MOA.
MOA?
Yeah.
Concerning what?
Concerning the
single source, single supply?
Yeah, single source supplier of via laser.
Yes.
And there was I think there were the Caspers, which is a different vehicle. And then also the house, I think that they were doing. The one that I signed when Mr. Mlambo had rejected was the house, because, as I said, we were already 3 years late. I might have been underestimating it, because now I hear it's 11 years. Maybe it would have been 5 or 6 years. Yeah. So the issue for me was the agency, and also because whenever I met the client, and we need to understand that these vehicles are not just vehicles to save lives of the soldiers, especially because these were South African vehicles, the house for the Hoefeester. It was important for us to get the PBL go through. And if Mr. Mlambo, for me, was delaying, and already we have a single, and we have proven proven that their laser has good quality in that field, and there is an MOA that has been signed. Why are we delaying? Because my issue was that we need to move with speed. Because up till today, as you have said, PBL has not been even achieved.
Yes. But just to confirm, I just want you to, we'll deal with whether Mr. Mlambo was right or wrong, and whether he was emotional, whether it was good business sense and so forth. I just want to make sure your 2.5, where you're referring to Mr. Mlambo being asked to approve the appointment of VR laser services after the MOA had already been signed, that's the MOA dealing with the single supplier, not the Hulls. Is that correct?
I think the single supplier included the house.
Well, that's not been the evidence of other witnesses, and the
Single
agreements
supplier,
don't reflect that.
The house, I'm sure you know, SC, that the house is just the body
Yes.
of the vehicle, whatever type of a vehicle that you have. So, being a single supplier, that means that body, that part of the body, will be supplied by via laser. Whether it's the Hoefeester or the Caspers, that's what I understood the MOA to be doing.
Okay, so yes, your evidence is different from that of other witnesses, but I don't think we need to go into a big debate with you about that. That's your opinion and your understanding. I understand that. But can I take you to to another bundle. If you can just put that bundle to the side, please. And Chair, may I ask your learned registrar to place before you bundle 1. Mr. Tsepe, would you mind just putting that bundle to the side and just finding bundle Denel number 1? I don't know if it's behind you or maybe in front of you on the left.
Denel bundle number 1.
Is that number 1?
Yes.
Yes, thank you. If you could open that, please. May I take you in bundle 1 to page 825?
825.
Yes. Now, 825, in fact, 824 is the start of that memorandum. Now, this is a memorandum dated the 29th of October 2015 from Ms. Malashlela, the then Executive Manager Supply Chain in DLS. And it was submitted to the Denel Supply Chain Executive. That would have been Mr. Mlambo, correct?
Correct.
I'm
And it
sorry,
refers to
Mr. Kennedy. Just pace yourself appropriately. We are 5 minutes away from stopping.
thank you, Chair.
Yeah, okay.
I'll just touch on this and then
No, that's fine, yeah.
we can continue in the morning if we
Yeah.
may then. Thank you, Chair, for the guidance. Now, this refers in the heading to a conflict between the policy and the signed MOU. Now, there's been sometimes people refer to an MOU and sometimes to an MOA, and you've indicated in your affidavit that you believe there was no difference between the two. In fact, other witnesses have suggested otherwise, but again, I don't propose to debate that with you now. But what she says is this: in giving the approval for the deviation from the normal procurement process and a list of suppliers to be used for the TS demo, the Group Supply Chain Executive gave an instruction that DLS must first explore how Denel vehicle systems, gear ratio, and LMT will be used in the project on condition that they meet the quality, price, and delivery requirements. Now, Ms. Malashlela has given evidence before this commission that this specifically was dealing not with the original appointment of VR Laser for the 217 or 183 hulls,
Yes.
but this in fact related to the later agreement that was awarded to VR Laser by DLS as a single supplier of relevant components.
This is a demonstration, so it's only one vehicle.
Only one vehicle.
Yes.
But she then continues and says this: furthermore, in terms of the approved Denel supply chain policy and the DLS supply chain procedure, DLS must first approach intergroup companies before procuring outside the group. In terms of the Denel group supply chain policy, under no circumstances, and here she's quoting from the policy, under no circumstances shall products or services that can be procured from a group entity or division be procured from an external supplier or non-Denel company unless there is approval by the group supply chain executive based on sound business reasons. Having identified a need for a single source supplier for the supply of steel components and fabrications, in May 2015, DLS signed an MOA with VR Laser for this scope of work. VR Laser is a 100% black-owned entity. In terms of the MOA, VR Laser prices must be market-related and in line with the provisions of the MOA before an order can be placed on them. Now here, she's referring to an MOA that was not restricted to a demo model. It referred to the MOA for the single supply.
Yes.
For multiple purchases of orders, correct?
Yes, correct.
Right. And she is referring here to the MOA having been signed in May 2015. And now she's saying there is a problem, effectively, that this has not complied with the Denel policy, which required that you cannot buy outside the group unless the group supply chain executive, Mr. Mlamba, has given his approval on the basis of sound business reasons. Are you with me so far?
Yes, I hear what you say.
Yes. Yes. And then she says, due to these contradicting positions, supply chain approached DLS Exco to make a decision as to whether to honour the MOA and place the order on VR laser or to follow the supply chain policy and procure from intergroup, namely DVS or LMT for this project. So this is so her department in DLS went to their management, or rather their Exco, DLS Exco, to say, well, which one must we follow? Must we follow the MOA or must we follow the procurement policy? Because the procurement policy seems to have been breached. And then she says, at the foot of the page, given the time frame, urgency and history, Exco has recommended that the work be done by VR laser. I hereby request permission to implement the Exco decision in this regard. Now, presumably you weren't involved in Ms. Malashlela's interactions with the Exco within her divisional level.
No.
Correct. So she's given evidence to the chair that you presumably can't comment on, namely that she told them, no, we can't continue with the MOA, although it's already signed, because this is a conflict with our policy. And she was then told, you're now instructed to put together the motivation. You can't comment on that, presumably.
No, I cannot comment on that.
Okay, thank you. Now, so then she gave evidence further, and Mr. Mlamba also gave evidence that this was then sent to him at group level, head office level, where he was the most senior person dealing directly with supply chain. And he, instead of signing above the word approval, where his name, it's misspelt, it's spelt as Denise Mlamba, it should be Dennis Mlamba, Group Supply Chain Executive. He refused to sign in there. And instead, he wrote the portion that's in writing here. You see that? And what he wrote there is NB, DVS and LMT must submit proof that they cannot meet the requirements prior to the contract being awarded to VR Laser. Now, so what he was saying in his evidence was this. Ms. Malashlela was correct to pick up that the MOA that had already been signed conflicted with the Denel Group procurement policy. Because if you were going to procure goods or services outside the Denel Group, where you already have DVS and LMT, there must be a good business reason, and he must be satisfied before he would give approval that there is a good business reason. So he's saying effectively here, I'm prepared to consider it, but both DVS and LMT will have to submit proof that they can't meet the requirements before I give approval. Now, that was his attitude. And his evidence is that LMT and DVS did not provide proof, nor did anybody else in DLS, that there was a good business reason that they couldn't meet the requirements. But instead, his evidence was that you then approved it, effectively overriding his decision. Is it correct that the word approved below the handwritten portion that I've just read is your handwriting?
Yes, it's correct.
And then it is in print, printed very clearly, GCEO, Z and Tsepe, yourself, correct?
Correct.
And is that your signature?
Correct.
Is that correct? Okay.
And is it correct that you were overriding his position?
Yes, correct.
Yes, okay.
It's not dated. I'm about to finish, if I may, Chair.
Yeah.
It's not dated. Can you recall when you signed this?
What is it, 29th October?
The memo is dated 29 October 2015.
I don't remember. Maybe
A few days after
a
that.
few days or a week or two.
Yeah. Interestingly, the title, I don't know if that's your handwriting, the bold written portion below your signature, is that your own writing?
No, that's not my writing.
Okay, somebody else presumably put that in.
Yeah.
And it doesn't indicate you then as being acting, it actually shows that you were then
It is not my writing.
the fully fledged GCEO.
Yes.
Yes. Can you remember when you signed this, whether by then you were still acting or whether you were the GCEO?
I think I was still acting.
Okay. Thank you. May I suggest, Chair, that the witness then proceed to explain why he took this decision and approved it in the morning when we resume.
You propose that he explains tomorrow morning, or you'd like that to happen now?
I know that you're under time pressure with other commitments, Chair. I was suggesting that he continue tomorrow so that we don't breach the time limit, but,
Yes,
but
yes.
I'm happy if you want me to proceed to ask that.
No. I think it's, let's do it, let's continue tomorrow.
Thank you, Chair.
Yes. As things stand, what's your estimate of how much time you would need with him before your next witness tomorrow? How much time do you think he will take?
I believe we should finish within an hour maximum.
Oh,
That's
okay,
my
all right.
estimation.
Okay. So should we start at 9 or 9:30?
May I suggest respectfully 9 o'clock,
9
Chair?
o'clock.
I know you have many
Okay.
other demands, but I think that we have a fairly busy day tomorrow.
Yes. Who do we have as tomorrow's?
After Mr. Nsepe, we've scheduled Dr. Nel.
Yes.
He was at LMT,
Yes.
and then after that, Mr. Van der Merwe,
Yes.
who has requested, and we need to approach you in chambers to ask for guidance in relation to his request to have the hearing virtually tomorrow.
Okay. All right.
But those are the two witnesses apart from the completion of Mr. Nsepe's evidence.
No, that's fine. Let's start and the person who would have been your second witness tomorrow, how long is he likely to be?
Dr. Nel, I would think probably about 2 to 3 hours.
Is that so?
Yeah.
Okay, let's start at 9 tomorrow morning.
Thank you, Chair.
Yes.
Thank you, thank you.
Mr. Ntsebe, we will adjourn for the day, and then we'll start at 9 tomorrow morning.
Thank you.
Okay, we adjourn.
All rise.